Well, hello there, ladies and gentlemen, and welcome back to Closing Arguments. I'm Ryan Ruff, your moderator. Great to be back with everybody as always. And of course, I'll be joined by really the star of our show, John or Jack Razumich, as many know him by, from Razumich Associates. We're rounding out season 2 here on the show. We're super excited to be wrapping up this season with a really interesting conversation, getting back to kind of that regular scheduled programming, if you will. You know, we took a lot of time and throughout this season to cover a very, very big popular case. I know so many of you enjoyed our coverage of, the state of Indiana versus Richard Allen, which again, we have full intentions to circle back to as new developments pop up in that case. But today, got a great topic we're going to be hitting. We're covering this idea of expert witnesses. We're going to get into what is an expert witness, of course, from a high level. We'll talk about scientific expert witnesses and what they can provide in a given trial. We'll talk about how these expert witnesses are ultimately used, maybe by the prosecution or the defense. And then, of course, a little bit of a hot topic at the end, a debatable topic, if you will. And that's, are expert witnesses really useful at the end of the day? But before we get into all of that, let's go ahead and say hi to the man of the hour. Jack, good to see you today. How we doing?
Hey, Ryan, not too bad. Big second season finale. It's exciting.
Yeah, absolutely. Absolutely. Expert witnesses, they're an interesting topic. We see it brought up in Law and Order and other media platforms where, an expert witness can come in and shape the entire way a trial or a case is going to play out. Some of that may be true, some of it, of course, not, and glorified a little bit in media. We're going to put some of that to bed, but also dive into some of the good details today. Why don't we just start from a high level, educate our audience for a second? Jack, what is an expert witness?
Basically speaking, an expert witness is someone who's got highly specialized knowledge that is outside of what a normal person would be capable or expected to be capable of learning easily, who testifies at a trial, either for the prosecution or the defense, or in the civil cases for a plaintiff or a defendant, about something that's supposed to actually help them to understand the factors that they're looking at. The specific definition for the state of Indiana is in Indiana Rule of Evidence 702. And that rule is a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. Expert scientific testimony is admissible only if the court is satisfied that the expert testimony rests upon reliable scientific principles. So one of the things that an expert witness actually is capable of doing is providing an opinion. And that opinion is going to be based off of their area of specialty. It's one of the very few situations where opinion testimony is actually viable in a court. Courts, of course, are primarily concerned with facts. But in certain circumstances, the expert is capable of providing an opinion. So that's kind of really quickly what it is. It's just someone who has technical knowledge or specialized knowledge that the people who are on the jury or a judge in many cases just aren't going to be expected to have because it's so outside of their realm of training.
Sure. And we just heard you rattle off there the state of Indiana's definition for an expert witness, but does that definition vary in any way, shape, or form when we're looking at, let's say, federal law?
There are a couple of minor differences between the federal standard and the state standard. Primarily, it involves with the federal rule, if there's going to be an expert scientific opinion, it has to be established in the evidence that there are sufficient facts or data that justify the opinion. In Indiana, that is left completely open to the purposes of cross-examination. I know that might sound like a distinction that really doesn't have a significant difference, but it actually is a pretty big one. In the federal courts, there has to be a showing that there is enough data, there is enough information for the expert to provide an opinion. And if that doesn't exist, the expert simply can't provide an opinion. In Indiana, an expert is allowed to give an opinion on whatever they're asked about, if it's in their area of expertise. And if there's insufficient data or information to justify that opinion, it's the defense attorney's responsibility to cross-examine them on that and make the argument that there's insufficient data. A good example of this that I can just use pretty quickly are standardized field sobriety tests in DUI investigations. Now, that's not expert testimony. We'll get to that a little bit later in the episode on how something like that is considered by the courts. But if it were expert testimony in the federal system, the standardized field sobriety test would need to be done perfectly pursuant to the NHTSA requirements, or the officer wouldn't be able to give an opinion on intoxication. In Indiana, the officer can give an opinion on intoxication, and then it becomes the defense attorney's responsibility to argue that the field sobriety tests were done incorrectly, or that there was some sort of other deficiency that makes this opinion incorrect. That's kind of the quickest and easiest illustration of how different that is. In the federal system, there has to be a showing that, yes, there's enough data. Yes, this is reliable. Now we can give an opinion. And in Indiana, we kind of do it backwards. The other major issue that is different between the federal rules of evidence as it relates to expert witnesses and the Indiana rules is Federal Rule of Evidence 706 specifically has procedures detailing the appointment of court-appointed experts in federal cases. We don't really have that in Indiana. There is a procedure to ask that expert witnesses be appointed in Indiana, which is, again, one of the things we'll talk about a little bit later in the show. But generally speaking, the only court-appointed expert witnesses that we ever have in Indiana are doctors when it comes to pursuing an insanity defense. If you're not pursuing an insanity defense, there's not going to be an automatic appointment of expert witnesses by the court. And even then, those doctors work directly for the court system. They don't work for the plaintiff, or sorry, they don't work for the state, they don't work for the prosecutor, and they don't work for the defendant. They are working directly for the court. So even there, calling them court appointed is not completely correct.
Mm-hmm.
But that is sort of the difference between the two.
Sure.
Is just the federal rules. They've got the conditions precedent, and they've got the ability to kind of say, okay, we need an expert appointed. We're going to go boom, 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 boom down the list.
Mm-hmm. Gotcha. Well, let's go to the who then. Who, Jack, can be not appointed, but qualified really as an expert witness in a given case?
I mean, kind of anybody. It's not complicated. As long as they can meet the sufficient threshold training, they can be qualified as an expert witness. For example, I was called to provide testimony in a post-conviction relief proceeding once. A post-conviction relief proceeding is it's effectively a trial on a trial. This particular case, the allegation by the defendant was that he had received ineffective assistance of counsel from his previous defense attorney. So I was called by effectively the plaintiff, the defendant / plaintiff in that case, to provide an opinion on whether or not I thought that the attorney's representation was deficient or fell beyond the normal standard of care. And I got qualified as an expert because, I went to law school. I've got specialized training that the public at large isn't going to have. I own a private criminal defense firm. So, I know the types of things that you would need to do to properly represent a person. So that qualified me as an expert. Again, it's just something like that. A lot of times what you'll see with experts are, of course, the more scientific type of experts, your doctors, your toxicologists, but even mechanics can be qualified as expert witnesses. Crash reconstruction experts. Expert is right there in their name, but the idea is that they have sufficient training, they have advanced training that they're able to kind of decipher what some of this stuff means. There is a difference between, and I brought this up with the DUI concept before, there's a difference between simply having a higher than average level of knowledge about something and being considered an expert. So, I have, as people can probably see if they've ever bothered focusing on the stuff behind me, there are a lot of toys, there are a lot of comic books back there. That is a big hobby for me. I know a lot about comic books, but anyone can go learn about comic books pretty easily. So, the knowledge that I've got might be more than the average person, but that's not necessarily going to be qualified as an expert because you can get it on your own. With the law, you have to have specialized training to do that. And that's sort of what the difference is between the two. But yeah, if you've got the training, you can be qualified. You just have to basically provide what your credentials are.
Sure.
And then the party who's presenting the expert witness asks the court, "Judge, I would like this witness to be qualified as an expert witness." And if it's a jury trial, the judge will tell the jury that they're free to reject the court's determination of this person as an expert. So you don't actually have to trust the experts if you're on a jury trial. You can completely disregard them. The judge saying this person is an expert doesn't make it so. For the most part, though, if you go through the proper credentials, if you go through the proper presentation of this is what this person's qualifications are, this is what they're testifying to, that's going to be acceptable.
Okay. Good to know. Well, let's shift gears now towards kind of the scientific expert witnesses that I think we see pop up a lot in, TV shows and things like that to weigh in on a given case. But, as you were reading definitions earlier, we had heard the phrase, reasonable scientific principles. Dive into what this really means and this idea of a scientific expert witness and why there's a little more going on here with regard to them as opposed to maybe, let's just say, a generic expert witness, if that makes sense.
The idea with scientific witnesses it's a concept of credibility. People trust doctors. People trust engineers that have letters behind their name. There's even a rumor that sometimes people will trust attorneys. The idea is that this person has some sort of specialized training that you're not going to get. So we want to make sure that if they are standing in front of the jury and if they are providing an opinion on something very technical, it is reliable. And the buzzword for that, as far as the legal system is concerned, is referred to as reasonable scientific principles. And that's one of those flexible, for lack of a better way of putting it, terms that doesn't have a particularly great definition that goes into it. The way that has developed over the years, there were two different major cases that dictate how we address expert scientific testimony in the courts. The first is what's referred to as the Frye Standard. And the Frye Standard is based off of a 1923 federal case, not even a Supreme Court case, just a federal case called Frye versus the United States. That particular case involved some question regarding the idea of systolic blood pressure deception, I think was the old-timey language they were using in that. Cutting through to translating that something that makes sense to people, basically lie detector tests. That's, it was about that. And what the Frye court basically said, and this was the standard nationwide for the better part of 50 years. And it's still the standard in about 23 different state courts. It's not the standard in the federal courts anymore. The standard in the federal court is the Daubert standard, which we'll talk about in a moment, and we'll talk about how those things overlap with each other. But the idea is that under the Frye standard, the court needs to determine that the scientific evidence is generally accepted by a significant portion of the relevant scientific community in order for it to satisfy the Frye standard. So what that basically means is if you can get a bunch of doctors to agree that this is appropriate, then it becomes relevant scientific evidence. And that's a little bit of a problem sometimes because, in 1923, eugenics was scientifically considered to be reliable and an acceptable way of determining things like who should be allowed to breed, who should be forcibly sterilized by the law. That's the scientific consensus on that. But it was accepted just as like, oh yeah, that's just what we do. The Frye standard itself doesn't really seem to provide a great deal, in my opinion, and a lot of other people's opinions, to really show their work, for lack of a better way of putting it. It's just, again, if you can get the consensus and say, well, all these scientists agree that this is the best methodology, whether it's the best methodology or not, that satisfies Frye. Mm-hmm. And the judge is the gatekeeper on this, and the judge is still the gatekeeper under Daubert, but there's at least a little bit more work showing that goes into Daubert. But yeah, it's not a great standard. The Daubert standard is a little bit better. The Daubert standard came about in this one actually came from a Supreme Court of the United States case. It's part of a trilogy of cases that were all decided at the same time for the purposes of re-examining the Frye standard in light of the adoption of the federal rules of evidence. The federal rules of evidence that we use today, that also form the basis of most of the state rules of evidence, really have only been around since the mid 1970s. So a lot of times what the rules of evidence were supposed to do, they're supposed to kind of codify and streamline all these various court decisions so that you could just pick up one book that said rules of evidence, see what the rules are, and that's going to be the relevant standard. So the rules of evidence, federal rules of evidence, discuss the concept of expert witness testimony. And the question was, does this overrule the Frye standard that was established in 1923? And the answer turns out to be yes. And the trilogy of cases that represent the Daubert standard, the first one would be Daubert versus Merrill Dow Pharmaceuticals, which discusses how Rule 702 assesses the admissibility of scientific testimony generally. General Electric versus Joyner, which discusses the concept that the judge is still the gatekeeper of deciding what is and is not considered to be relevant scientific evidence. And Kumho Tire Company versus Carmichael, which just basically, again, expanded a little bit the judge's gatekeeping concept on that. So what we have under the Daubert standard is the judge has to be the first line of defense, for lack of a better way of describing, over does this evidence come in or not. The second is they make a determination as to whether or not it is relevant and reliable, which requires the judge to ensure that the expert's testimony is relevant to the task at hand and it rests on a reliable scientific foundation. And that reliable foundation involves actually determining the expert's methods and their methodology and their reliability. So again, it goes with the issue of, how is this peer reviewed? How much has this been cited by others? Has this theory been relied on by others in the scientific principle for additional research that moves forward? And then the general concept, again, like it's is the theory or technique employed by the expert generally accepted in the scientific community? Is it subject to peer review and publication? Has it been tested? Can it be tested? Is there a known error rate in this concept? And the most important thing is, was this research generated independently for reasons other than this litigation? Or is this information that's been set up specifically for just this case? And judges won't always allow things in. We had a DUI trial. Gosh, we had a DUI trial, I want to say almost 3 years ago at this point in time. The defense that the defendant wanted us to pursue was a defense that's referred to as autobrewery syndrome. Autobrewery syndrome is an argument that there is some sort of imbalance in the bacteria that's in your stomach that breaks down sugars and starches, that instead of breaking them down into the normal energy stuff like insulin or sucrose that your body normally does, the bacteria in your stomach actually ferments those starches and effectively generates an intoxicating effect into your bloodstream. That's a pretty novel idea. I had heard about it before that trial, but this is the first time that anyone ever came up to me and said, hey, I suffer from this condition. And to his credit, he had doctors. He had research scientists that were looking into it. The court did not allow the evidence of autobrewery syndrome in, and his argument was that this is not a widely enough accepted concept in the scientific community to justify the idea that this is an explanation for the intoxication.
Yeah.
Basically, the idea was an auto brewery defense would have been an example of involuntary intoxication, because if your body is breaking down starches and turning them into alcohol, you didn't knowingly become intoxicated. It would have been interesting to see how that played out.
Very. Wow.
I know that he had an appeal. I was not involved in the appeal, so I don't know. Maybe I'll look into that. Maybe I'll do that after we're done, and we'll do a catch up episode for episode 3 of episode 1 of season 3. But yeah, so you do have that gatekeeping function.
Yeah.
And just because you have someone who says this is scientifically reliable or they have the right language for it, that doesn't mean it comes in.
Sure. Well, Jack, we've done a nice job of kind of painting the picture on who these expert witnesses can be, in a generic form, of course, as well as the scientific side of things. Let's get into what they're ultimately used for and how they're leveraged by the defense versus the prosecution. So let's start with obtaining. How does one go about obtaining an expert witness, securing their time, and being able to utilize them in a given case?
It varies depending on who you are.
Sure. Like many things in life.
Yeah. The state of Indiana seems to have an unlimited ability to access expert witnesses. Again, if you run with the idea that, an expert witness is going to be someone with specialized technical training, a lot of those people are employed by the state for one reason or another. The scientists at the Indiana Department of Toxicology, for example, they're state employees. They work for the state of Indiana. They are capable of testifying as to how the gas chromatograph headspace works for the purposes of determining weight of alcohol during the vaporization process. I've heard that many times in trial. I don't know what it means any more than anyone on jury does. But they can testify about, like, this is the machine, this is the procedure, this is what it's testing, this is what this data chart reads out as. So they're technical witnesses, they're specialized witnesses, and they work for the state of Indiana. So the state of Indiana can just call up and say, hey, I need a toxicologist to come down here. There's still chain of custody issues. You still have to have, they still either have to have worked on it or they have to supervise somebody who worked on it. They don't just get to show up and say, hi, I'm a random toxicologist, let me talk about this. Crash reconstruction experts, again, same situation. A surprising number are employed by the Indiana State Police. And we've had more than one fatal or serious crash that we've had to work on defense with, where the crash reconstruction expert who is employed by the state police, therefore, again, an employee of the state of Indiana, was able to decipher what the black box material inside your car actually does. I don't know if you know this, but I didn't know this until we started doing this work. A lot of modern cars do have black boxes very similar to how airplanes do. What they'll do is they kind of have this kill switch, for lack of a better way of putting it, where if your speed drops suddenly, like if you slam on your brakes or if you slam into something else that forcibly stops you, it will somehow recapture and log your data for like how fast you were driving at so many feet before impact or so many seconds before impact. And state police, a crash reconstruction expert can decipher that, and they can explain to the jury, prior to impact, the brakes were pressed, or prior to impact, this individual was driving, 60 miles per hour. And like 2 seconds before impact, they were driving 70 miles per hour. So you've got at least an argument that there's an attempt to slow down. So the state always seems to have access to these. Mm-hmm. If you're the defense, it's a lot more complicated.
Sure.
And this goes back to what we were talking about before. With the federal rule has a very specific procedure for how you would request the appointment of an expert witness. In the defense sphere, the surest and easiest way to do that is, of course, money. Expert witnesses need to be paid by someone. Again, because the state is a monopoly on power, they don't have to pay their own witnesses more. I think there's a little bit of overtime that goes into it, but it's nowhere near what we have to pay on our end. Public defender agencies can have written into their budget so much money for expert witnesses during any budgetary fiscal year. So if the chief public defender looks at the docket and says, okay, we've got 3 murder trials that are going to require ballistics experts for one reason or another. And we know these ballistic experts are going to charge us, $5,000 for reviewing the case and another $5,000 for going to trial. So we've got this $10,000 set aside for this expert witness. So we're not going to be able to use an expert witness for this toxicology for this DUI case over here. So that is kind of factor. Like, it can be one of those things. It is just legitimately part of the public defense budget. And that applies even if you don't have a full-time public defender. Not every county in Indiana has a full-time public defender agency. There are a lot of counties where the public defenders are just local attorneys who have contracts with the state for the purposes of providing these representation services. There's still a budget for the public defenders. If the public defense budget for, let's say, Hancock County, where I live, although we do have a chief public defender now, we don't have a full-time agency, but we do have a chief public defender. But let's say the budget for Hancock County is, we'll just throw a number out there, like $100,000 for the year for all public defense services in Hancock County. If you need expert witnesses and you are potentially exceeding the budget that has been set aside for public defense work, you have to go to the judge and ask them, which is what we do in the private sphere as well. The Constitution, but the state and federal Constitution do provide you with a defense at no expense to yourself if you need it. Most people rightfully consider that applying to attorneys, which is correct. If you cannot afford your own attorney, the court will appoint one for you. What a lot of people don't know or don't think about is just because you have a private attorney doesn't mean that you don't have the ability to access public funds for the purposes of maintaining and building your defense. Again, there is a constitutional right to a defense and to have that defense provided for you if you can't afford it. It would be like basically telling someone, you came here for it. We promise you a hamburger, but you can only afford the bun, so we're keeping the meat, and here's your delicious bread. It's that same general concept. Like,
Sure.
if you're promising to provide something and you tell them, like, if you can't afford it, we'll give it to you for free. And it's like, well, I can only afford so much of this. It's like, oh, well, I'm sorry, you don't get the rest of it. That's that same general concept that applies for defense work as well.
Sure.
The process that we use when we're asking for the appointment of an expert witness or funds for an expert witness, we have to file what's referred to as an ex parte request for expert witness funds. What an ex parte request is, it is a pleading that only the judge gets to see. The other side doesn't get to see it. So if the defense was requesting an expert witness, the petition is filed under seal, so the prosecutor can't see it, the public can't see it, just the judge can see it. What we have to do is we have to basically lay out, this is why we want an expert witness, this is what we expect the expert witness to be capable of testifying to, and this is the price range that we've looked at for what the expert witness is likely to cost. And then the judge makes a determination as to whether or not the county coffers are open for it. Obviously, if you can afford your own private expert witness, you don't have to go through that process. And you can keep your expert witness a surprise until the very day of trial, although they do have to, of course, be eligible and available for depositions by the state. But there's no record of what you're thinking about having them do. And you don't even necessarily, having an expert witness doesn't necessarily mean that you need to have them testify. We have, in certain cases involving high-level assaults, we have used expert witnesses in the areas of psychology and psychiatry to review the facts of the case, interview our clients, and provide us with an opinion as to, this is what I think could be argued to the court with regards to any particular penalties, most notably the requirement that people register. There are certain circumstances where people can no longer be required to register as a sex or violent offender under the law. And it's useful sometimes to know going in hey, if you put this forward, this is the type of argument you need. This is what the experts are looking at to determine whether or not we even want to advance that. Because the last thing you ever want to do is, not put the best foot forward when you're dealing with your clients. And the expert witness can provide that information.
Yeah.
And if you're not planning on calling them, you don't have to disclose it. It's basically like hiring a private investigator or a extra secretary to kind of help organize things for you.
Yeah. No, that's really, really an interesting point there. And one thing I want to have you double click into is this idea of an expert witness versus, let's say, a skilled witness, somebody who has skill in something, but aren't necessarily constituted as an expert. Talk me through the difference between these two and where they're applicable.
It's kind of like, the easiest way to describe it is a skilled witness would be considered a level below the expert witness. The expert witness, again, is someone who has the specialized training, the specialized knowledge, the stuff that you have to go away for specific skills and learning, educational facilities, training, certifications. Those are the things that make you a specialist, because there is a lot of effort that goes into that. There is a lot of very technical knowledge that goes into it. Skilled witnesses are going to be witnesses who have different types of professional experiences that the public at large might not have, but don't necessarily rise to the level of expert. A great example, police officers are considered to be skilled witnesses. So going back to the DUI example that we used earlier with regards to the field sobriety test, a police officer will be qualified as a skilled witness to testify. I went through this training on performing standardized field sobriety testing. This is the training that I had. I use this training, daily, weekly, what have you, in the execution of my duties as a police officer. It represents a heightened degree of knowledge that technically anyone could get. The National Highway Traffic and Safety Administration, if you really feel like putting the effort into it, you can attend those. And like I've attended an SFST class. Now, granted, I'm an attorney, so I've got perhaps maybe a couple of extra inroads to find this stuff, as opposed to someone who just decides, I would like to see what they do at the DUI training schools, to jump in on Google. But you can theoretically find that. Anyone can find that. Nursing is another great example. A nurse can testify as a skilled witness that, when I saw his head drooping to the side and he was drooling on himself, like, I believe that he was having a seizure or a medical situation, because they have skill and they have training. Now, they're not going to be capable of testifying as to causation. They may not be able to testify as to this is what caused this, but they can certainly testify that based off of my experience working as a nurse, handling trauma patients, this is what I saw and this is what I did as a result of it, because this is what we normally see. It's a fascinating thing that kind of, again, you border on that issue, like how far can you get into the ability of providing an opinion compared to just the whole general concept of invading the jury's province on that.
Well, that's a beautiful segue into kind of the final theme, if you will, that we wanted to hit on the conversation. And that is, are expert witnesses really even useful? My first question to you to kind of open this up is, what can an expert witness actually testify to? And then the double click here is does it ultimately even matter if they testify and provide value? I think this is really the hot button topic here of this conversation, though.
My opinions on expert witnesses can vary wildly. And the reason that I say that is, I think that there's an expectation, or at least a willingness to understand on the part of juries, that a defense attorney is going to argue that the person on trial is the victim of circumstances, or not guilty, or not responsible for one reason or another. And the prosecutor is going to argue that this is the second coming of Hitler and the streets are going to run red with blood if you don't turn in a conviction. there seems to be a general concept that, everyone is willing to accept that as just part of how this process works. What expert witnesses, and even to some extent skilled witnesses, will do in these situations is add a degree of credibility to one of the arguments. So with regards to DUIs, which are pretty much, again, like 90% of the expert witnesses that I run into are in DUI related situations. They will be able to testify as to the effects of alcohol on the human body at varying heights, weights. They can get all the way down to differences in the way alcohol will affect the biological sexes. Like that is chemistry, that is pharmacology, that is technical specialized knowledge. And they can provide an opinion to the jury that, based off of the scientific principles that I rely on, this person was intoxicated at the time of this event. That's not considered to be an opinion on the ultimate issue, because it's an opinion based off of the medical science that they're looking at. It's very, very damning, as you can imagine, to have someone with the title doctor as part of their name to stand up on the witness stand and say, based off of my training as a medical professional, this is what is going on. And it gets interesting sometimes if you have dueling doctors, because you can have a doctor testify for the defense that may have a completely different opinion as to the situation. We at one point in time, we had a director for the Indiana Department of Toxicology whose testimony was that there were never any circumstances ever where it was safe to drive a motor vehicle after consuming marijuana for at least 30 days. And that doctor's testimony was because THC is stored in fatty cells, and your brain is primarily a giant, fatty lump of cells. You never know when, latent or dormant THC is going to just basically be released out into your bloodstream, and all of a sudden, boom, you're high again and you're intoxicated by the effects of THC. Think acid flashbacks is the easiest way of describing that, but marijuana. That's what this doctor's testimony was. And there were other doctors that we were capable of putting on and did in one situation that said, like, well, this is a ridiculously unreasonable concern, because here's how much THC is going to be stored in these various different types of fatty cells. And this doctor's opinion is, overly sensationalized, inappropriate, what have you. We did still lose that trial, by the way, in case you were curious. The law in the state of Indiana is that operating with any controlled substance or its metabolite in your bloodstream, it doesn't matter how long ago it was, it is technically a crime. So the fact that there was marijuana in his system, even though we were able to argue that he wasn't intoxicated as a matter of law, he was still driving around with marijuana in his system. So it was still a conviction. So that's we have screw statutes on that. Anyway, back to the point that we were talking about, though. It becomes a credibility argument over who is going to be more credible. And part of the biggest problem that I think that there are with expert witnesses from the defense perspective is because the state has such easy access to them, because the state is more financially capable or simply incentivized to bring these expert witnesses in. It puts the defense at a significant disadvantage, because it's not every defendant that can afford to have their own scientist come in and testify, this is how marijuana actually affects the brain, or this is why the breath testing machine is not reliable to determine whether or not this person's actually at 0.08, or if we should accept the margin of error that would put them below 0.8. These are thousands of dollars of expenses, and a lot of times the defense can't have them. Mm-hmm. And it gets especially hard when you're dealing with cases involving assault, and you'll have witnesses who come in there and say, what we typically see from these types of victims, or what we typically see from this category of patient, what the jury hears is the jury hears someone who has a form or a degree of specialized training or actual letters behind their name, someone who presents this credibility that says this is what we normally see, and the subconscious push at that point in time is, if you're seeing this now, you should consider it to be reliable because this is what we see.
Right.
I've had cases where when we talk to the jury afterwards, the jurors, as they're gushing over the prosecution, will say, that testimony from the forensic interviewer about how this is what we usually see in these types of witnesses, that cleared it up and made it so understandable for me because that's exactly what I was seeing on that video that we watched. So again, it is a powerful thing.
Sure.
I think it's more powerful for the state because they seem to have them on a more regular basis.
Yep.
That's kind of what it is.
Yeah, I think that comes down to the bottom line of really this whole conversation today on expert witnesses. Jack, I know you and your team, you navigate complex situations and trials like this a lot, where you're dealing with expert witnesses being brought on by the state or not, but still you guys work through a lot of complex situations. And, we wrapped up our last conversation surrounding, the idea, we had this true attorney confessions, if you will, and it really boiled down to, seek representation. Make sure you have somebody in your corner should you need to go toe to toe, with the prosecution and be facing a trial. Jack, for anybody out there that hears, today's topic or just understands that common, concept at whole and could really benefit from opening up a conversation with you and your team to, see what, their options are and whether or not you guys could help them, mitigate circumstances that they're up against, what would be the best way somebody could contact you guys and pick your brain and seek representation, perhaps?
As always, the best way to contact our office regarding questions about the law, questions about your specific case, or questions about a case that you might need representation for is just to call us at 317-983-5333. Someone's always answering our telephone. We're happy to discuss the concept of what can be done for you and whether or not expert witnesses are going to be necessary. I will say that in the 18 plus years that I've been doing this, there have only been a handful of situations where I genuinely thought that it was important for us to have our own expert witnesses. Maybe that's a testimony to we've not been getting the remarkably complicated cases compared to other ones. But there are situations where they are useful. A lot of times experts will be more valuable in supplemental proceedings than they will in the underlying proceedings. I think one of the rare times that we actually had to get our own expert witness was it was an insanity trial, and there was a split between the court appoints two doctors, and the doctors reached different conclusions as to whether or not the defendant met the legal definition of insanity. So we had to get our own expert witness to provide an opinion on that, and that we had to disclose this is our witness. They have been paid by the defense to provide this opinion. But what they were able to do is they were able to explain, okay, this is why, Dr. X said insane. This is why Dr. Y said sane. As Dr. Z, this is my determination, and this is why I think Dr. X was more reliable, and you should trust him as well as trusting me. And that resolved the case. We didn't have to go to trial on that one. That extra expert witness was able to get us to the bargaining table and get the case resolved the way that it needs to be. So there is value in it. And, you never know until you ask. We're always going to be happy to answer your questions.
Sure. Well, Jack, look, I appreciate you carving some time out of your busy schedule. I know you got clients to serve, so I'll let you get back to doing that. But looking forward to being back on the next one with you. And thanks for wrapping up a great second season of the show with me.
Absolutely. Looking forward to it.
All righty. Well, hey, gang, we're going to take one final moment here, as always, and thank you, our audience members, for stopping by, taking some time out of your day to be with us here on the show. If you enjoyed today's discussion, you learned a thing or two, I know I did, make sure you hit the subscribe button on whichever platform you check this out on so that you don't miss out on any great content coming your way here in the near future. Before Jack, I'm Ryan. We're going to go ahead and say so long now, but once again, we appreciate you being with us on Closing Arguments.